The Supreme Court's 6-3 emergency ruling has quietly changed how laws are enforced across the United States, and most people are only now beginning to understand what that really means. This was not a long, televised decision debated for months in public view. It arrived through the court's emergency process, moved quickly, and immediately altered the legal ground beneath federal agencies, states, courts, and ordinary Americans. What looks technical on the surface is actually a major shift in how power operates nationwide. At the center of this ruling is enforcement, not legislation. Congress writes laws, but enforcement determines how those laws affect daily life. For years, enforcement has often been stopped or reshaped by lower courts issuing broad nationwide orders. One judge in one district could block a federal rule everywhere in the country. That practice became common enough that many people assumed it was normal. The Supreme Court has now made clear that it is not. The 6 justices in the majority concluded that courts were drifting beyond their constitutional role. Judges exist to decide cases between parties, not to supervise national policy. When courts extend their rulings to people who are not part of a lawsuit, the majority argued, they cross from judging into governing. That shift matters because judges are not elected and cannot be held accountable by voters. The dissenting justices saw the situation very differently. They warned that without broad court orders, unlawful government actions could remain in effect for long periods. In their view, nationwide injunctions are sometimes the only realistic way to prevent widespread harm. This disagreement reveals a deeper divide about how rights should be protected in practice, through structure or through intervention. The emergency nature of the ruling is especially important. Emergency decisions are used when the court believes waiting would cause irreversible damage. By acting quickly, the justices signaled that they saw the existing enforcement system as a serious problem, not a minor procedural issue. That alone explains why this ruling is drawing attention far beyond legal circles. The immediate impact is already visible. Federal agencies are reassessing enforcement programs that were previously blocked nationwide. Policies that had been frozen may now move forward in many regions. State governments are reviewing how aggressively they can enforce their own laws or challenge federal ones. Lawyers across the country are rewriting strategies that once depended on sweeping judicial orders. For businesses, the change introduces new complexity. Uniform nationwide pauses once provided clarity. Now, compliance may depend more on geography. A rule enforced in one state might still be blocked in another. Companies operating across multiple jurisdictions will need to monitor legal developments more closely than before. For ordinary Americans, the consequences may feel indirect at first, but they are real. Laws affecting healthcare, employment, immigration, education, or voting may now apply differently depending on where someone lives. 2 people under the same federal law could experience different outcomes based solely on location. Supporters of the ruling argue this reflects federalism. Critics argue it undermines equal treatment. The majority insists that these concerns do not justify expanding judicial power beyond constitutional limits. In their view, if laws are unclear or harmful, the solution is better legislation, not stronger courts. By narrowing judicial reach, the Supreme Court is pushing responsibility back onto Congress and the executive branch, where voters can apply pressure. This ruling also reshapes incentives. Agencies may act more confidently without fear that one adverse ruling will shut them down nationwide. States may test the limits of enforcement more aggressively. Advocacy groups may need to bring multiple cases instead of relying on one national lawsuit. Power has not disappeared. It has shifted. Lower courts now face a period of adjustment. Judges must carefully tailor remedies and avoid broad orders that exceed their authority. Some will comply strictly. Others may push boundaries, inviting further review. Conflicting rulings are likely, increasing the chance that more cases will return to the Supreme Court. Politically, the decision changes accountability. When courts step back, elections matter more. Policy outcomes become more directly tied to who controls Congress and the presidency. That was a central argument of the majority, which views democratic processes as the primary safeguard of rights. Critics remain skeptical. Remembering historical moments when courts played a key role in protecting minorities, they worry that limiting judicial power could leave vulnerable groups exposed. Whether those fears are realized depends on how responsibly lawmakers and agencies use the authority now returned to them. What is undeniable is that enforcement in America has entered a new phase. The tools that once allowed quick, nationwide judicial intervention are no longer guaranteed. Laws may now take effect unevenly, disputes may last longer, and political pressure may increase. This 6-3 emergency ruling is not the final word. It is the beginning of a broader recalibration of power. How it ultimately reshapes daily life will depend on the choices made by courts, lawmakers, agencies, and voters in the months ahead. Now that the Supreme Court's 6-3 emergency ruling has reshaped how laws are enforced, attention is shifting from the decision itself to its long-term consequences. Court rulings do not merely settle disputes. They alter incentives, redistribute authority, and change how institutions behave. This ruling is already doing all three, and its effects will grow over time. The most immediate consequence is uneven enforcement. Without automatic nationwide injunctions, federal policies may now operate differently depending on location. A regulation blocked in one judicial district may take effect in another. Supporters argue this restores constitutional balance by limiting judicial reach. Critics warn it creates a fragmented system where federal law feels inconsistent across state lines. Federal agencies are adjusting quickly. Previously, a single unfavorable ruling could shut down an enforcement program nationwide. That risk encouraged caution. Now agencies may move faster, knowing that legal challenges may apply only to specific plaintiffs. This could increase enforcement activity, but it also raises uncertainty for individuals and businesses trying to understand their obligations. States are gaining renewed influence. Attorneys general who once relied on nationwide injunctions to block federal policies must now pursue narrower strategies. At the same time, states defending controversial laws may enforce them more aggressively outside limited jurisdictions. This shifts conflict back toward federalism, where states test national authority instead of relying on courts to decide instantly. Advocacy organizations face a strategic reset. Litigation has long been an efficient way to achieve national change through a single case. That approach may now require multiple lawsuits across multiple courts. Well-funded groups will adapt more easily. Smaller organizations may struggle. This raises concerns about access to justice, even as constitutional limits are reinforced. Ordinary Americans may not feel the impact immediately, but it becomes personal over time. Workplace rules, environmental protections, healthcare access, immigration enforcement, and voting procedures may vary more sharply by region. Rights that once felt uniform may now feel local. The majority views this as democratic accountability. The dissent fears it leaves vulnerable populations exposed. The ruling also sends a clear message to Congress. For decades, lawmakers have delegated responsibility to agencies and relied on courts to resolve disputes. By narrowing judicial power, the Supreme Court is pressuring Congress to legislate more clearly. If lawmakers want uniform national outcomes, they must write laws that leave less room for interpretation. Lower courts now face closer scrutiny. Judges must carefully tailor remedies and avoid broad orders exceeding their authority. Some will adapt cautiously, others may test boundaries, leading to conflicting rulings. This period of adjustment almost guarantees that more cases will return to the Supreme Court. Politically, the decision reshapes responsibility. When courts step back, elections matter more. Policy outcomes become more directly tied to who controls Congress and the executive branch. That shift was central to the majority's reasoning, which sees democratic processes as the primary safeguard of rights. The deeper question is whether constitutional structure alone can protect against abuse. The court is betting that limiting judicial reach strengthens democracy by restoring balance among branches. Critics argue structure without strong judicial enforcement can fail in practice. The outcome depends on how responsibly elected officials use their authority. This ruling does not end conflict. It redistributes it. Power is moving away from individual judges and back into a system requiring negotiation, legislation, and political accountability. That process is slower and messier, but it aligns more closely with constitutional design. As this new enforcement landscape takes shape, one fact is clear. The Supreme Court has changed the rules governing how laws take effect nationwide. The consequences will not appear overnight, but they will define how authority, rights, and accountability function in America for years to come.